I think we're ready to reconvene. So if folks could sort of resituate themselves into, I guess I call it listening mode, that would be terrific. Any folks just outside the doors, if you'd invite them to come back in, we're ready to resume. That would be appreciated. Well, thank you. I'm looking forward to hearing from our lunch speaker. When we started the planning work to begin to construct the outlines of what we hoped this symposium might be, I contacted a really good friend of mine. His name is Professor David Martin, who I'd worked with when I worked in Washington at the Department of Justice many, many years ago. And I contacted David because he is, for my money, in that sort of top 5 group of folks who are so extremely knowledgeable about immigration law and policy. Spent some time as the General Counsel of INS in that structure, was the Deputy General Counsel for DHS, and now is back on the faculty at UVA. And so when we were trying to think of people who might be appropriate to include in this symposium, I contacted him. And among the people he said, well, if you can get him, it would be really terrific, and he would add so much to your discussion, was Peter Vincent. And so I was so pleased when we reached out to Peter that he not only expressed a willingness to be a part of our symposium today, but was just so enthusiastic about being a part of a gathering that would include the perspectives among which you've already heard earlier today. And so we were really pleased when Peter accepted our invitation to share some thoughts with us during this lunch period today. So let me tell you a little bit about him. Again, you have an abbreviated summary of his professional achievements and educational achievements on page 7 of your program. But let me, as I say, tell you a little bit about him, highlight some of this before I ask him to come forward. He is the Principal Legal Advisor for the U.S. Immigration and Customs Enforcement Office, otherwise known as ICE, which is within the U.S. Department of Homeland Security. In that capacity, he's the principal legal advisor for his agency, and he oversees the largest legal program in DHS, which has nearly 1,000 attorneys, 359 legal and mission support specialists, so you can see he's responsible for overseeing a pretty substantial legal operation. He spent some time in the private sector before joining INS, which has become ICE. He was a litigator for the multinational firm of Bechtel Corporation and did some work there. And he's also got some, I think, impressive international legal experience. In November 2006, he was appointed to serve as the U.S. Department of Justice's Assistant Judicial Attaché at the U.S. Embassy in Bogota, Colombia. Was ultimately promoted in that office to the role of Judicial Attaché. And so he brings a rich combination of experiences and professional achievement to this conversation. I look forward to hearing from Peter, really to give us a perspective from the federal perch, particularly the ICE perch. We've been talking about the role of states and the intersection and interplay between state and federal policymaking. We thought it would round out and provide an essential element in that conversation if we had a chance to hear from a federal official who plays a key role from the federal perspective as it relates to immigration law and policy. And so please join me in welcoming Peter Vincent to the podium.
Thank you very much, Professor Robinson. Thank you for inviting me, and special thanks to Dean Roming as well for inviting me. It is a great honor to be here, and I very much appreciate the opportunity to discuss some of what I think are fascinating, interesting, and I dare say sexy issues facing our nation today. And I can assure you, Dean Roming, that nobody in Washington considers Kansas a flyover state. And that will become increasingly clear as we get closer and closer to the national elections. I was born and raised in San Francisco, but I have a particular fondness in my heart for this state. My mother spent her formative years here in Kansas City and attended the University of Kansas, where she had the opportunity to view in person one of the greatest athletes in Kansas history, and that was the great Gale Sayers, whose career was tragically cut short by an injury. And I have a particular fond spot for this particular great institution as well. To be completely honest with you, as I always will be, I had not heard of Washburn University. Prior to graduating from the University of California at Berkeley, I had heard of University of Kansas ad nauseum from my own mother, who strongly encouraged me to attend. But I joined the Peace Corps, like a great many University of California at Berkeley graduates set out to save the world, not rule the world like my colleagues across the bay at Stanford. And very, very enthusiastic and innocent student, and met a guy in our training course there in Guatemala during the very, very dark years of Guatemala, and a time when the death squads were, of course, running rampant, who wore a Washburn sweatshirt. He proceeded to wear that sweatshirt each and every day for 4 months as we made our way through training in the indigenous highlands in Guatemala, which has a climate similar to the one that we're enjoying today. It was cool and quite foggy, and he asked him, to be completely honest, I've not heard of this, and he would spend hours every week talking about the great things and the great history. Obviously, Bob Dole and many, many others who we've heard about today, and took a great pride in this fantastic school. So thank you all very much for inviting me. I'm also, and you'll have to forgive me, as a graduate of the University of Virginia School of Law, where I did have the opportunity to take every course offered by the great David Martin, who has asked me to do everything I can to bring Professor Robinson back to Washington, D.C. You will forgive my reference to Thomas Jefferson. Those of you who know University of Virginia School of Law graduates know that we are almost obligated to make some sort of reference to Thomas Jefferson, and I will do that now and get it out of the way. But it was nice that Mr. Charles referred to the Declaration of Independence, and that in this great room very much reminds me of the rotunda at the University of Virginia, at the main grounds, not at the law grounds. And I know that you are working on, at least considering possibly expanding the law school, and I hope that you're able to, and I hope that you have a lot of alumni support, not only from the law school students that are here, but as the undergraduates who are here, and I'm glad that you are all here as well. I almost missed my flight to Kansas City International because, like the esteemed representative, Mr. DeGraff, I am married to a foreign national, and we just went through our somewhat traumatic interview with our friends at U.S. Citizenship and Immigration Services to establish the bona fides of our marital relationship. I, of course, not wanting to be charged with influence peddling in all of the application procedures associated with removing the conditional basis of lawful permanent residency, never mentioned and would not mention what I do for a living, and the fact that I am the principal legal advisor and that I am, in fact, a political appointee. So they put us through the very challenging question and answer session regarding how we got to know one another, how many telephones we have in our house, which I thought I was being clever when I said we have no telephones in our house, because we don't. We all use cell phones now. But evidently it did not go over quite very well with the examiner, so she held us over for an extended period of time. So I almost missed my flight, but I am very, very glad I am here. I would like to spend a few minutes letting you know a little bit about what ICE does. The organization was established, the entire department was established, of course, pursuant to the Homeland Security Act of 2002. We were stood up as a federal department and a federal agency on March 1st of 2003. And the first word in our title is somewhat of a challenge for us. It's something that we take very seriously, and that is immigration. And we do have exclusive authority over representing the United States government through our nearly 1,000 attorneys, and all immigration exclusion, deportation, to the extent that we do those types of proceedings, and obviously what we now call removal proceedings, which is just a fancy name for deportation proceedings. And we take that very, very seriously. However, since 2003, we have grown not only in numbers as an agency, but also in our authorities. And that has proven to be exciting for us, but it's also proven to be a bit of a challenge. We are 20,000 strong within ICE. As the Secretary of State referenced, we have 7,000 trained criminal investigators. We are the investigative arm of the entire Department of Homeland Security. We are second in numbers of criminal investigators only to the great FBI, but we continue to grow. In addition to criminal investigators, which form part of Homeland Security investigations within ICE and within the department, there are a number of sworn law enforcement officers that make up what is now called enforcement and removal operations. These individuals actually detain, and only when necessary, detain individuals for purposes of removal. They also engage in fugitive operations, where they go out and look for individuals, the vast majority of whom have committed crimes, subjecting themselves, if they're lawful permanent residents, to removal, and they are very much involved in our ongoing enforcement operations. The agency, in addition to those growing numbers, has been blessed with the ability and the statutory and regulatory authority to do much more than immigration. In fact, immigration, although it will continue to be at the heart of what many of our attorneys, agents, officers, and mission support specialists do each and every day, will become, I believe, a smaller part as the agency continues to grow. And let me explain that. We are now authorized, pursuant to memoranda of understandings as well as statutory provisions, to investigate and to assist in the prosecutions involving weapons trafficking violations. Likewise, we are authorized by memoranda of understanding between various agencies, statute, and regulations to also become very much involved in narco-trafficking investigations and prosecutions. We are deeply involved in intellectual property rights violations along with the FBI, and we are growing significantly in that area. Many folks don't realize that we are the agency that handles more child exploitation, trafficking, pornography, and sex tourism cases of any other federal agency in the United States. That is something that we take very, very seriously. We have specific statutory authorities which enable us, with respect to sex tourism, to grab these individuals from airports they are leaving from in the United States or from where they are domiciled, before they actually get on planes en route to places where there are significant vulnerable populations, to include, of course, Southeast Asia. And that is something that we take very, very seriously. In addition, ICE is very much involved in counter-proliferation of nuclear or other sensitive technologies and weapons that are, as you well know if you read the papers, often at issue with respect to countries who may not share our particular views of the world and our particular need to make sure that the world is safe for our way of life and for all democracies. And that's something that we take very, very seriously. ICE has currently, we are in each and every state of the United States, as well as every territory. But what most folks do not realize, and this is an area that we are growing at significantly, we are located in 67 offices in 47 different countries around the world. Our presence in U.S. embassies around the world is an area through our Office of International Affairs that is growing very, very quickly and very largely. We're involved in visa security matters. We're obviously involved in working with our host country counterparts, law enforcement, and intelligence gathering to find ways of securing the homeland from as far away from our physical borders as is possible, and that is something that we take great pride in. Our attorneys, of course, are involved in each and every one of those particular aspects. If you had asked our attorneys in 2003, 2004, 2005, and during the nascent stages of the growth of our agency, what they did, approximately 80% would have told you that they spend almost all of their time handling the very important work that is removal proceeding representation on behalf of the entire United States government. I would suggest that that is changing, it has changed, will continue to change. Probably about 60% of our attorneys now focus exclusively on immigration court proceedings. The other 40% handle all of the other important responsibilities that we've been blessed by Congress to have received in terms of counterproliferation, intellectual property rights violations, narco-trafficking, weapons trafficking, national security cases, and counterintelligence cases. And that will continue to be the trend of of our organization. As I've said now already twice, we have 1,000 attorneys spread throughout the United States, 60 different offices broken up into 26 different regional counsel offices called the Offices of the Chief Counsel. More and more of those attorneys as well are being physically embedded with Homeland Security investigations to support their criminal investigative work. More and more we are also allowing them to serve on 2-year details with the United States Attorney's offices, which they are doing now to the tune of $10 million out of my budget. But it is important work, and the United States Attorney's offices will tell you that it really is a force multiplier for them, especially given the Department of Justice's very, very serious budgetary constraints they have right now. As I said, 60 of them, 2-year tours. They come back to the Office of the Principal Legal Advisor either in their home offices in the field or at headquarters, obviously having a much greater understanding of the intricacies of criminal law and the sensitivities that the Department of Justice deals with so well each and every day. It is fascinating work, and I'm proud that we have a representative from our Kansas City sub-office here in the audience today. She actually took annual leave to attend this event because she knew she did not know I was going to be here. Had she, I suspect that she might not have taken annual leave and would have spent her time doing something else. But thanks to Professor Robinson and the great panels that he's put together, obviously it is time well spent for her, and I'm very, very glad and proud that she's here with me. I wanted to talk about 3 things today that are of relative interest and some controversy. I will start with prosecutorial discretion. That is something that you've heard about quite a bit. It's something that is a source of great congressional interest, as well as public and media scrutiny and interest, and I think appropriately so. We'll talk a little bit also, while I have the time, about Secure Communities, the Secure Communities program, which you also, no doubt, if you read newspapers or listen to the news or talk to people anywhere at any time, have heard something about. Quite controversial, like prosecutorial discretion, and I'm not sure exactly why it's controversial, but I hope to address those. They're actually, between prosecutorial discretion and secure communities, controversial to different groups of people and different constituencies, and I find that fascinating. We'll talk a little bit about that. And then, of course, I would be remiss if I didn't spend some time talking about federal preemption and what my particular views are on that. I thought the last panelist, it was absolutely fascinating and a great exchange of ideas and different perspectives. I learned, as I always do at these events, something about it that I did not previously know, so I appreciate the opportunity to talk to you about this. One thing that I have said over and over again during the last 2.5 years that I've been honored and privileged to serve in this political appointed position is that at ICE, we are guaranteed to upset exactly 50% of the people 100% of the time. And we do an extraordinarily good job of that. It is the nature of the business. I am proud to have the opportunity to do it. Not that I necessarily enjoy upsetting people, but I understand that that is part of what we as a nation and what we as a people, when it comes to questions of immigration, when it comes to questions of detaining aliens, when it comes to questions of deciding who gets to come to the United States and be part of the greatest country in the world and who gets to stay, and when we kick them out and why we kick them out and when it's entirely appropriate to kick them out, and we should not be apologetic when we do that. But it does seem to make the front pages of the newspapers, the news. I don't have many easy days. I often am privileged to speak at events like this one, and one of my favorite arenas to speak is exactly at universities and law schools. And I can tell you that last year I was given the opportunity to speak to a law school in Connecticut. There were credible threats made against me. I was escorted by Connecticut state troopers into the law school to give a luncheon speech, much like I'm privileged to do today. And the individuals in that particular instance were angry and made no bones about it, that ICE was too focused on enforcement, that ICE was not sympathetic enough to humanitarian causes and individual cases. And in fact, the blogs used a particular term, and many blogs, whichever side of the aisle you're on, often take extreme views and use language that's not necessarily in the best interest of a mature public debate, called me a jackbooted thug for representing an agency that on a daily basis violated basic human rights. Those individuals, of course, were, or perhaps not of course, but we're talking about ICE's unprecedented effort to remove aliens from the United States. We have just released the newest numbers of the last fiscal year, the number of aliens removed from the United States, just shy of 400,000 individuals. 215,000 of those 400,000 are criminal aliens. We will continue to prioritize our efforts with limited resources that we're blessed to have from Congress in an effort to remove as many individuals that we possibly can, with a strong emphasis on those that represent national security interests, that those that represent or reflect individuals that pose a danger to our communities, to our basic society, our ways of life, individuals who in their own countries have persecuted others on the basis of religion or gender or race, and that's something that we take very, very proudly. But unfortunately, the message sometimes and the efforts sometimes get drowned out by the understandable but somewhat difficult to always address high rhetoric. Prosecutorial discretion. It is inherent in the nature of our enforcement function and not dependent on any particular statutory or regulatory provision to engage and exercise prosecutorial discretion when and only when appropriate. It is something that is exercised appropriately each and every day by every federal, state, local, and tribal entity that has law enforcement authorities, not only in the United States, but all over the world. Now, we may differ as to what priorities actually merit the decision to not exercise prosecutorial discretion, and that is something that we should discuss, and we should discuss openly and transparently. But the argument that a law enforcement agency as large as the Department of Homeland Security, in particular Immigration and Customs Enforcement, does not have prosecutorial discretion strikes me as not at all helpful. In addition to that inherent nature of our enforcement function, we have received guidance going back to, at least in writing, 1976 from one of my predecessors, the great Sam Bernsen, who was general counsel of then Legacy Immigration Naturalization Service. And it's my favorite document. You've heard a lot about prosecutorial discretion, memoranda and guidance, and I'll talk briefly about that. And we often think, because we have computers and we have these blasted Blackberries, that we are somehow evolved as a people and we become more intelligent and more effective, especially when compared to those individuals that were operating in the dark ages. I still remember of dictaphones and typewriters. The 1976 prosecutorial discretion memorandum was clearly written on a typewriter. And the paper itself, the legend at the bottom is buy U.S. Treasury bonds or bail bonds or something like that. And it's a short document. It's on our website, so I encourage you to look for it. Very basic. Establishes the inherent nature of our enforcement function, giving us the authority to exercise prosecutorial discretion. And it does so in a very pithy way, in a very common sense way. Since then, a number of other memoranda were issued. Bill Howard, one of my predecessors, issued a document in 2000 which went into much more detail. Doris Meisner, Doris Meisner in 2000, the former commissioner of INS, and then Bill Howard in 2005 issued a document. Of course, Director Morton has issued civil enforcement priorities. That was last year. And most recently, and most often in the news, is his June 17th prosecutorial discretion memorandum. We take that very, very seriously. It's a hard balance, I can tell you, for our officers, our agents, and especially for our attorneys who represent the government in immigration courts each and every day. What we are asking them to do, and all of them, you understand, joined the Department of Homeland Security out of a sense of patriotism, out of a sense of public service, out of a sense, frankly, of being prosecutorial-minded. Many, the vast majority, have served either as judge advocate generals or as prosecutors, local or state or assistant United States attorneys. But we are asking them to do something that I don't think any other agency, whether it's law enforcement or intelligence gathering, here in the United States or anywhere else around the world, and I have some credibility when I talk about that because I have had a number of overseas experiences, is asked to do. We are asking our folks to balance the incredibly important, the fundamental, the primal essence of our mission as an agency, protecting the homeland, securing the borders, establishing national security integrity, protecting our communities from gang members, from pedophiles, from drunk drivers, on the one hand, with balancing that against, on the other hand, the important needs involving immigration cases that necessarily touch upon serious humanitarian matters. Sympathetic cases involving individuals who have spent nearly or all of their lives in the United States looking for a better way of life, many of whom, unfortunately or tragically, have U.S. servicemen, spouses who, in the various wars that we are gloriously engaged in around the world, obviously most recently in Iraq and Afghanistan, have lost their ability to adjust their status to that of lawful permanent residence. Individuals that are facing illnesses that will certainly send them to another place, hopefully a better place. Looking at those sympathetic cases in a way that through the prism of our enforcement responsibilities, our Homeland Security responsibilities and authorities that we have, make some sense of the system. Understanding that we are blessed with very large appropriations from Congress, but we could not hope to round up, if we make that decision as a nation, and remove 11, 12 million people. We have to focus our priorities on those cases that make the most sense. And it's something that we struggle with every day. Again, those cases, national security cases, obviously, integrity at the border, human rights violator cases, all sorts of criminal cases. And we have to also protect the integrity of the immigration process. This is protecting the sanctity of the asylum process, which is a sacred right to individuals. Unfortunately, as I said, I'll always be candid with you, I see each and every day gross fraud by individuals who may not come here with the intent to cause damage to our way of life or our homeland, may come here because they want, quite simply, those of you who are parents, and I'm not blessed yet with that experience, a better way of life for their children, greater educational opportunities, that unfortunately engage in asylum fraud. And that is something that the agency also takes very seriously. And we are working very closely with our colleagues at U.S. Citizenship and Immigration Service, as well as local prosecutors' offices, to go after the individuals who are engaging in that fraud and who are stripping the sanctity of the asylum process, which unnecessarily cheapens it. Something that we take very, very seriously. What has been surprising for me is the level of animosity and high rhetoric over the prosecutorial discretion issue. It has been engaged in, as I said, since time immemorial. It's been appropriately engaged in by Republicans and Democrats alike for all the right reasons. We can quibble about what cases should fall within the proper exercise of prosecutorial discretion, but it's hard to quibble, and we should not quibble with the basic concept of it. I will tell you that we try to get it right each and every day. You're all quite familiar, those of you that are here that are old enough, with the story of the three bears, or Goldilocks. And I know I run a risk of mocking myself when I talk about Goldilocks, given my current follicle challenges. But we're trying to get it just right, and that's a challenge for us. We are criticized by one particular group because we are too enforcement-minded. I can tell you the emails that I get on a regular basis from well-intentioned non-governmental organizations that are outraged that we have removed unprecedented numbers of aliens. As I said, 400,000, just shy, 397,000 this year and the previous fiscal year as well. They're outraged that we're removing anyone from the United States. At the same time, I get emails from equally well-intentioned, bright, smart people whose motives I do not and will not question, suggesting that we should not be engaging in perhaps any prosecutorial discretion, or perhaps we're engaging in too much prosecutorial discretion and that we're not using the right parameters to decide which cases appropriately merit the exercise of prosecutorial discretion. We're trying to get it right. We take it seriously. It's something that is a challenge for us because we handle 350,000 immigration removal cases each and every year. We have 1,000 of attorneys. That's a lot of attorneys. But 350,000 immigration cases that we handle each and every year is a real challenge. Let me talk very briefly about secure communities. It is a simple and common sense approach. It utilizes an already existing federal database exchange to identify individuals who have been booked for criminal violations, to submit those particular fingerprints to the Federal Bureau of Investigation, which has been done for decades, to determine whether or not those individuals may have wants or warrants for criminal activity or convictions in other states, to determine important questions as to whether or not the prosecutors, whether state, local, or tribal, should exercise discretion, or whether or not they should prosecute someone who obviously represents a danger of repeat offenses. Also, determinations regarding whether or not the individual should be allowed out on bond. To find out if someone picked up by a local trooper here in the great state of Kansas had been arrested 3 years before in Missouri or in Texas or in California. It requires the FBI to share that information with the Department of Homeland Security to determine whether or not, in addition to any previous criminal activity the individual may have been involved in, there are immigration issues that need to be addressed vis-a-vis a person who had previously been encountered by an immigration official. That information sharing between two federal government law enforcement entities is not something that state, county, local jurisdiction can opt out of. There's been a lot of controversy about that. Admittedly, the agency, especially in the early years, did not do a very good job of messaging that particular reality. Now, a state or local entity can decide that when it arrests and books that individual on a alleged criminal offense, does not want to send that information through that's fingerprints, to the FBI to determine whether or not he or she may have engaged in criminal activity in another state. You do so at your own peril. Once that information is shared with the FBI is obligated to share it with DHS, and we will react appropriately. That does not mean that in each and every one of those cases, ICE is obligated to then place an immigration detainer on that particular individual. At that point, the matter, as the Secretary said, is referred up to the Law Enforcement Support Center up in Burlington, Vermont, and a determination is made as to whether or not that previous immigration issue, whether it was an encounter by an immigration official, whether it was a previous removal order, whether there was an illegal re-entry, whether or not we decide to exercise prosecutorial discretion and use our scarce resources to work to determine whether or not we're going to detain that individual after he or she has served, if they've been convicted, their criminal time, or whether, as so often happens, the authorities, state, local, or tribal, decide, because we're all dealing with scarce resources, we would rather not expend our scarce resources on this individual. We would rather that ICE picked him or her up, detained him at their expense, and removed him from our communities, because we gain the same thing, other than in obviously particularly violent crimes where individuals do need to spend time in jails and prisons. That is something that we take very, very seriously. The department has established a committee that looks into ways that we can improve the communication, the socializing with individuals who don't quite understand and make allegations that are completely inappropriate and untrue regarding racial profiling. Back in the day, what would happen would be an ICE or an INS official would go to a local jail, and he or she would look at the log of booked individuals. And I'm not suggesting that racial profiling ever took place at that time. But what could possibly have happened theoretically is that well-intentioned agent or officer could have looked for every last name that looked like it might be from Asia or Latin America or Sub-Saharan Africa or the Middle East and said, we need to talk to this individual, have an interview, determine whether or not he or she is in the country illegally or has committed a crime that subjects them to, at that point, in those times, the term was deportation. All individuals, whether they're United States citizens, on visas, students appropriately here, illegally here, are, once booked, bounced off immigration databases. It's not a last name, it's not an ethnic group, it's not a religion, it is the fact that they've been booked, and that all goes over. So I wanted to address that, because I do think there has been a bit of disinformation, which, as I said earlier, admittedly, may be at least a result of ICE's inability to communicate that clearly. One of the best places to find criminals is in the jails. And that's what Secure Communities is about. We're looking to remove these individuals when appropriate from our communities because they pose a danger to our quality of life and to our families. And we take that very seriously. And we will continue to work with the non-governmental organizations to make sure that we're educating state and local tribal law enforcement officers as to ways that we can all work together to get the true message and the meaning of this program out. Professor Robinson asked me when we first spoke so many months ago to talk about federal preemption. Let me start by saying, especially that you all have full stomachs, I will avoid any and all references to political or partisan positions on this particular issue. I have my own opinions, and I feel strongly that the area of immigration law is a matter exclusively for federal operations and activity. That is not to say that the state, local, tribal individuals, officers that we work with each and every day do not assist us through, as the Secretary of State said, the 287G program, where local law enforcement officials are essentially deputized to assist us in the effort to identify, when necessary, detain and remove aliens from the United States. Through the Law Enforcement Support Center, as the Secretary and I have both mentioned, we are extremely grateful for the incredible cooperation we get from the local authorities. After all, the local authorities are the individuals who on a day-to-day basis work in the communities, understand the situations, understand particular cultural differences between somebody from southern Texas and somebody from northern California. And we could not do the important work that we do without their assistance and cooperation. And we take that very seriously, and we greatly respect what we do. I don't mean to sound flippant, but I will say something that I hope you remember, and that is when the federal government in the area of immigration enforcement needs the cooperation and insistence, we will ask for it. And we have asked for it. And we have never been denied the opportunity to work with our state, local, and tribal counterparts. As I said again, they do an incredible job. They work with us. They educate us each and every day. They help us do our job. We would be lost, frankly, without them. Now, the Secretary mentioned, as I did, that ICE currently has approximately 7,000 certified, trained criminal investigators, and that we could not hope to secure the borders or to locate, identify, detain when necessary, and remove individuals within the United States. That is something that I don't agree with. First of all, and be very clear, 7,000 immigration investigators. ICE has 20,000 employees. CBP, Customs and Border Protection, one of our sister agencies in the Department of Homeland Security, has nearly 40,000 employees. They have more, the term has become now part of the dialogue, boots on the ground at the border than ever before. And they do an incredible job of doing what they can on a very long border in very difficult circumstances, facing very, in some cases, dangerous odds. I spent 2.5 years in Colombia doing everything I possibly could to identify and remove narco-traffickers and extradite them, I should say, remove from Colombia, extradite them to the United States, individuals that posed a real security threat, not just to Colombia and not just to the United States, but now, as we are seeing more and more, to global stability. Individuals that are incredibly well-armed, incredibly sophisticated, that hire out of the best universities of the world, the best chemists to get 4 different harvests out of the cocaine plants, who hire out of Germany to this day some of the best shipping engineers in the world to help them develop semi-submersible and now submersible craft to transport that dope to Mexico, Guatemala, and obviously to the United States. And they face incredible challenges because those individuals now are leveraging, unfortunately, the cartels in Mexico to transport that dope to the United States. They do an incredible job each and every day, and we're very, very thankful for them. But in a constitutional system, the authority, the power to regulate immigration matters, in my opinion, falls exclusively to the federal authorities. There are reasons that have already been much better articulated by the very excellent panel this morning as to why that's the case. The one thing that I did want to mention, obviously, is the fact that it does impact foreign affairs in a very significant way. Not that the states, and I'm a big believer in states' rights, not that the states don't already have very important relationships, trade, education, otherwise, with other nation states, but it does impact. I can tell you that we have received numerous calls from the chiefs of missions of a number of embassies in Washington representing countries all over Latin America, Southeast Asia, and Africa regarding this particular issue as it relates to Arizona and, of course, as the Secretary said, Alabama. And it's something that's a real challenge for us. We need to have a universal system that makes good sense and is transparent and folks understand the process. And I happen to think that the federal government is best situated to do that. I look forward to further discussions on this because I am learning quite a bit. It's very, very valuable. And I certainly don't have all of the answers on this particular issue. I see my time is running very short. I just wanted to thank you all very much. These sorts of opportunities are incredibly important, not just through the formal process of prepared papers, and you can tell I'm a bit old school, 3x5 cards still, certainly no PowerPoint in my future, but the discussion, the formal discussion here on the panel, but those discussions during breaks as well, over dinner, perhaps over a cocktail or a soda, are incredibly important. And being able to learn from one another, regardless of one's political viewpoints, I think is incredibly important. And I can tell you that the Department of Homeland Security is certainly committed to that. I cannot tell you how pleased and honored I am that we have representatives here who have an incredibly busy schedule, and that this is a real significant issue for you. You know, I've gotten into arguments with NGOs who have argued, this should come as no surprise to you, that many states have engaged in their own ad hoc patchwork legislating in the particular area of immigration, not for, as I think the Secretary of State referenced, purely fiscal reasons, but there may be some element, according to these NGOs, of latent racism. I discount that. I think states and the representatives are doing the best job that they can, well-intentioned, trying to deal with a system that is very complicated and that Congress is still working on. And I am hopeful that there will be comprehensive immigration reform. I do not fault the states for wanting to find solutions to issues that affect them each and every day directly in many ways, educationally, obviously in terms of the provision of medical care, and provision of providing a fair wage to individuals that are authorized to work in the United States. And I think having these conversations is always constructive. It's always incredibly important. To the students in law school, I encourage you to seek service in honor of your state or your county or your federal government. There's nothing more rewarding to me than being a public servant. And I spent quality time in the public world as a law associate with a couple of mega firms and then with a mega multinational organization, and I was honored to do so, and I had great experiences. You won't hear me criticize that. But the sense of giving back to my community that I've been able to do since I came to the government in 2002 is unparalleled. And I really strongly encourage you, at least at some point in your career. I know this is a very expensive place to attend, as my place where I went to law school is to attend, and you may have to pay off those loans. But like I said, we're trying our best to get Professor Robinson back into the federal government. He has, Dean, just so you know, told me under no circumstances whatsoever will he leave his particular position here and the great work that he does. But I do encourage you, who are law students, to at least consider the public service, whether it's, again, with a state, local, federal, tribal organization, in the legislative branch or the executive branch. I think you'll be forever grateful for the experience. And for those of you who are law students, or are not law students, but are undergrads here, I encourage you to at least consider law school. It's given me many opportunities. Doesn't mean you have to be a lawyer, but I truly think that it teaches you a way of thinking, and it certainly gives you opportunities. With that, thank you all very much. It's a great honor to be here on this great campus. Particular thanks to Professor Robinson and to Dean Romig for being here. Thank you all very much.
Peter, thank you so much for those comments. Thank you for giving us that perspective from a federal agency that is deeply involved in intended or not, controversial ways as it relates to these really important issues. And we're so grateful that you were able to make the trip and take the time to share your thoughts and perspectives with us. And thank you as well for that message about public service and its value that you gave at the end of your talk. That's greatly appreciated as well, and certainly an important part of what the Center for Law and Government wants to promote on this campus as well. So thank you so much. We have for you as well wonderfully engraved pen and pencil set as a small token of our appreciation for your time, your insights, and your willingness to share both of those things with us here today.
Thank you, sir.
At this time,